Good evening. Good evening and welcome to the summer lecture of the Inner Temple History Society. My name is Donald Cryer and I'm the chairman of the society. And I'm delighted to say we have got an extremely interesting talk ahead of us this evening. But before I turn to that, let me just say one or two things about what's happening for the rest of the year. We have two talks in the autumn term. We have, on the 29th of October, an unusual talk in that it's going to be more of a dialogue than a talk, where Dr. Tom Kinnimont, who is Master of the Revels, is going to chair a symposium with two of the leading experts on Milton, because as you may know, the Inn has purchased a very rare copy of Paradise Lost, which is annotated by the Master of the Revels to Queen Anne, with the names of numerous members of the Inn. And so it seems very likely that what he was planning to do was to put on some form of dramatization of Paradise Lost, actually in the Inn, which raises all sorts of rather fascinating questions, which hopefully will be considered by the experts at the symposium. And Master Kinnimont, Tom Kinnimont, will be asking the questions Melvin Bragg style to see if he can pull out the right answers in a way that the rest of us could all understand what's actually happening. That's on the 29th of October. And then on the 11th of November, we have the Selden Society of Four Inns lecture. That's a rather sort of backwards way we're doing it this year. It would have been the Inner Temple's turn to host it. But the Middle Temple moved rather quickly and snuffled our speaker, who is actually a bencher of this inn. And that is Lord Sumption. And what was agreed as a sort of peace treaty was that we would run jointly the Four Inns talk and the Inner Temple History Society talk, the Middle Temple History Society talk, as a sort of unified event. And it will take place with our venture in the Middle Temple. And Lord Sumption has been a little coy so far as to the subject, but it's bound to be rather interesting. I can't imagine he would be giving anything less than a fascinating talk. So that's the 11th of November. Those talks, the Four Inns talks, tend to book out very quickly. So if you think you might be interested, which I hope you are, I suggest you, as soon as you see it advertised, you move quickly to reserve a place. The Four Inns talk next year will be here and will be delivered by a Middle Temple bencher, Lord Burnett. And so we have a series of fairly distinguished speakers, but swapping around a little bit. Those history talks have been proved a great success in terms of the public and attendees. And so we're pleased to be able to host that, or will be pleased to be able to host that in 2026. Today, we have Professor Lobban, who is not any longer a professor at the LSE, I think, although he was advertised as such. He's moved on to Oxford, where he is a senior research fellow now at All Souls. He's a leading scholar in the field of legal history. His published works run for about, I think, 12 pages, and that's just the titles. The various subjects he's looked at are quite fascinating. A whole panoply of matters involving legal history and beyond. If I were to start to read even the titles of his published works to you, we'd be here all night. So I'm not going to spend time doing that. We're very lucky that he's taken an interest in what I think is rather a fascinating subject in terms of family law. And as a family lawyer, I'm really looking forward to hearing it. I've had the benefit of reading the article upon which he based it, first of all. I don't know how much it's changed. I haven't read the talk, but if it's as interesting as the article, we're in for a fascinating time. The really interesting thing that I found was the enduring nature of the problems involving the state and others, in this occasion Dr. Barnardo's, playing what might be described as a do-gooding role in the lives of families and children. And it is fascinating to see how long ago it all started. So, Michael, over to you. Thank you very much.
Thank you. Well, thank you very much for the very kind invitation. It's a delight to be here and to be speaking. I have to say it feels very slightly odd to be giving a talk on the religious and rather bitter sectarian disputes between Dr. Barnardo and two cardinals, probably within moments of the new Pope being announced. Slightly coincidental there. So Thomas Barnardo was born in July 1845 in Dublin to a Prussian father and an Irish mother. Unlike his older brothers, Thomas was not educated at Trinity College Dublin, but was apprenticed to a wine merchant at the age of 14. The Anglican Barnardo became increasingly involved with evangelical groups as a teenager and joined the Plymouth Brethren. At the age of 21, he then came to London, where he wanted to become a missionary and to go to China as a missionary. But arriving at a time of cholera and seeing the extreme poverty and distress around him, he changed plans and enrolled as a student at the London hospital. Barnardo did not finish his medical studies because his interests soon changed from medicine. He began to teach at the nearby Ragged School and in 1868 set up his East End juvenile mission in Stepney. I can give you a picture. There we go. While his interests were originally in the religious education of children, Barnardo was soon concerned with the amount of homelessness and destitution in the East End of London. And that led him to acquire his first proper home, and you see the picture of that here, again in Stepney. Thanks to a wedding gift on his marriage in 1873, he was able to acquire another home and start a home for girls as well as boys. As a hard worker and relentless self-publicist, Barnardo's expanding homes were paid for by very successful fundraising, which was assisted by his flair for publicity, which included photographs of rescued children before and after. You can see here, once a little vagrant, now a little workman. On a number of occasions, Barnardo found himself embroiled in controversies. In 1875, he fell into dispute with some other rival philanthropists, Frederick Charrington and George Reynolds. There were criticisms of his lifestyle and his methods of operation, and in the course of this dispute, Barnardo attacked his rivals in two anonymous pamphlets signed A Clerical Junius. They responded with a pamphlet entitled Dr. Barnardo's Home's Startling Revelations. So you can see there's quite a lot of bitterness behind it. Beyond the matter of personalities, there was also a question of how charities should be regulated. Should they be regulated in a way to distinguish between the deserving and undeserving in the way that the Poor Law was run and what the Charity Organisation Society favoured, or should it be done in Barnardo's way, which was much more open and comprehensive? There were also accusations from his enemies about his character, his methods, his financial management. The episode ended with Barnardo first suing Reynolds and then having the matter referred to arbitration, an arbitration which had finished by 1877. The arbitration, with one lawyer and two laymen, recognised the importance of his homes, declared them to be very much worthy of public confidence, and these disputes were widely publicised in the press in the 1870s, and to some degree they made Barnardo nationally known in a way he wasn't before, so much so that in fact the name of his homes changed to Dr Barnardo's homes, as they were later constantly known. But it nevertheless proved a little bit embarrassing to Barnardo. Questions were first raised about his medical qualifications. Was he really a doctor? And that prompted him to get the proper qualifications from Edinburgh. His refusal to answer questions about who exactly authored these Junius letters also raised questions about his character. And then there were questions asked about the before and after photographs, which it turned out were staged. They weren't really the children as they came in. They were manufactured for publicity purposes. And also he then had to hand over management of the finances to a board of trustees. But nevertheless, although there was a little bit of negative publicity, he survived this with his reputation intact. It's at this point that he also returned to Anglicanism from the Brethren. He now goes back into mainstream Anglicanism. Barnardo's homes continued to flourish in the 1880s. By the middle of the decade, he's getting donations of £100,000 a year, and his publication, Night and Day, was circulating with about 120,000 copies a month. He also then began to send children overseas, and in particular to Canada. In 1882, he sent 100 children to Canada. First, they went to a distribution home in Hamilton, Ontario, and then were lodged out with other families. In fact, Barnardo himself went to Canada in 1884 for 3 months to build up his network. He also began then to send children to stay with families outside London, particularly in Essex. And by the 1890s, about 1,000 children a year were being sent to these homes outside of London, homes of individual, normally labourers. When Barnardo took in children, he generally asked parents to sign an agreement which gave him permission to send the child anywhere in the UK or the Empire or Europe. It also stipulated that the child could not be taken out of the homes without Barnardo's consent. And there was a stick as well as the carrot of having your child looked after, which is if you took your child out, you would have to pay a weekly fee for the sum that the homes had to pay to look after the child. Barnardo's battles in the 1870s had showed him to be feisty and determined, and to have a great flair for self-publicity, and also to be a man not averse to using some slightly underhand tactics for what he saw as the greater good. And these characteristics were ones which would be evident in the 1890s when he fell into a long-running battle with a Catholic agency which sought to provide its own homes for destitute children. His main adversary was the gentleman on the left, the Bishop of Salford, Herbert Vaughan, and also the gentleman on the right, Cardinal Manning. Manning was Archbishop of Westminster until 1892, and Vaughan then succeeded him. Vaughan helped to set up in 1886 a Catholic Protection and Rescue Society, which sought to counter the work of Protestant agencies who they feared were bent on proselytizing and converting Catholic children. Vaughan was as determined to save Catholic souls as Barnardo was to save Protestant ones. And in an era when there was an increasing number of agencies providing homes for children, one strategy of the society was to intervene on behalf of Catholic mothers who wanted to move their children out of the Protestant home where they'd been put into a Catholic home. And Vaughan himself was very active. By the end of the 1880s, he'd already intervened in about 30 or more cases. And he used the writ of habeas corpus, and this was the remedy, the legal instrument, which was used in almost all of these cases to take children out of the homes. For his part, Barnardo was highly suspicious of the Catholic agencies, whom he accused of only being interested in the destitute, as he put it, when goaded on by sectarian jealousy. He saw the hand of the Catholic authorities behind every claim from a destitute woman for the return of her child. And as we'll see in the rest of the talk, the disputes which were found in many, many cases really came to a head in two suits that went to the House of Lords. One was a dispute over the custody of a boy called John Jones, sometimes known as John Roddy, in Barnardo and McHugh, which reached the Lords in 1891. And 1 year later, in Barnardo and Ford, it was over the fate of a boy called Harry Gossage. And we'll see they've raised different issues, but both interesting about Barnardo's methods, but also about the legal points discussed in them. So I want to begin by looking at the battle for the custody of the son of Margaret McHugh, otherwise known as Margaret Roddy. Her son John was the illegitimate son of Margaret and John Jones. They had cohabited for 20 years before 1881, and they had two surviving children, one much older than the other. They were poor. They lived in a single room in Carlisle Street in the East End, and after a while, John, the father, left the home. Margaret then began to live with John McHugh, a labourer at the St Marylebone Stone Yard, and they then married in 1886. 2 years later, in June of 1888, John, the boy, was admitted to Barnardo's homes, with Margaret signing the standard agreement saying that she would not remove the boy without consent for 12 years until he was of age, and she would pay for each week he had been in the homes if she took him out. John was lodged in one of the homes in Stepney, where he was occasionally visited by his mother. But since when she visited, the managers of the homes thought she was sometimes a little bit the worse for drink, and they found her a little bit rude and abusive, at the end of 1889 they moved him to St Neots to lodge with the family of a labourer, and didn't tell the mother where they'd put him. Margaret was therefore distressed at the fact that her son had been moved to somewhere she didn't know where he was. She wrote to ask where he had been placed. At this point, through her niece, she also made contact with a Catholic priest who put her in touch with the Cardinal's solicitor, a man called Dudley Leithley, who we'll come across quite a lot. He was busy dealing with a raft of Catholic claims against Barnardo, and he'd regularly written letters to the press, and you can see one of them here. He says to the editor of the Standard, "I trust that none of your readers will be misled by Dr Barnardo into believing that he can retain a child until money due for its keep is paid. He has no power whatever to do so. The father or mother may or may not be liable, in many cases I fancy they would not, for the keep of the children under the agreements they sign, but it is absolutely clear a law that the non-payment of money claimed under such agreements does not justify Dr Barnardo in detaining the child for a single hour." So they have this kind of battle in the press and also in unpublished correspondence, because Leithley is the one who is always writing and asking questions about the children, and it's often Barnardo who's replying in person. Faced with a request from Leithley about John, Barnardo bluntly asked whether he was going to be sent to a Protestant school or a Catholic school. That's the first question. Leithley replied that it was likely to be a Catholic school, and Barnardo then proved himself unwilling to hand over the boy, though he offers to bring him back to London where his mother could visit him. He claimed that he had no rights over the boy, but he only wanted to safeguard his best interests, and he didn't see why the mother should be able capriciously to take back a child she had deliberately and willingly committed to him. Barnardo also threatens her with the contract, the very thing that Leithley says is not an impediment. But when it comes to litigation, that's not one of the main arguments he's putting forward. In litigation, he talks about the best interests of the child, that that's his real concern. At issue, in this case, and less so, but a little bit also in Henry Gossage's case, was the nature of parental rights. And this was an area that had been much debated in the 19th century, both in the common law courts through the writ of habeas corpus and in chancery, which exercised a wider jurisdiction to protect the welfare of children, derived from the Crown's position as parens patriae. The common law had long recognised the right of a father of legitimate children to their custody. As the Victorian campaigner Caroline Norton found out, the common law allowed fathers to deprive mothers of any access to their children if they chose to. They could take them away and lock them away from their mother. But for a father to be deprived of the custody of his children, he had to have been guilty of such gross immorality that the child would be in danger of contamination by living with him. And it's on those grounds that the poet Percy Bysshe Shelley was denied custody of his children in 1817, both because of his gross immorality, as the court saw it, and also his religious beliefs, his atheistical beliefs that were anathema to the likes of Lord Eldon. So fathers had also the right to control their children's education, even after their death, by the appointment of testamentary guardians. And courts were very reluctant to interfere with the rights of the father to determine the religion of the child, though there were sometimes cases where the courts would do so, where they would also take the child away from or not restore the child to the father. Where the child was no longer living with the father, as where the mother had taken the child away, the courts would refuse him a habeas corpus to get the child back if the child was at the age of discretion and could make up its own mind. The age of discretion was determined to be 14 for a boy and 16 for a girl. Furthermore, the Chancery would deprive the father of custody if his behaviour had been such as to be taken as a waiver of his rights. For example, if he had allowed the child to be brought up by a very wealthy relative, and to take the child back might lose some benefits the child would get from that relative. But as Ben Griffin has showed in a recent very interesting article, the commonest and most bitter disputes over custody in the 19th century were ones to do with religion, not simply where the parents had separated, but where you had what were called mixed marriages between Catholics and Protestants. What religion was the child to be raised in? As was confirmed in the famous case involving the Agar-Ellis family between 1878 and 1883, a father had the right to determine the religious education of his legitimate children, regardless of their own views or those of their mother. There was also much case law considering the circumstances in which a father's instructions regarding his religious education, the child's religious education after his death, could be disregarded. And there were certain circumstances in which you could disregard the father's religious wishes after his death. If, for example, he had allowed the mother to raise the child in her religion during his life, he was taken to have waived his rights. Equally, if the father's religion hadn't been acted on, his religious desires hadn't been acted on, and the child had developed faith in another sect or another group, then the court would disregard the child's wishes. Also, if the father had signed a prenuptial agreement, even if it was unenforceable, that was taken as a waiver of his rights. But there was some debate about how you would actually apply this. Did you ask the child? How did you determine it? In 1857, in a case called Sturton and Sturton, Lord Justice Knight Bruce interviewed a 9-year-old boy to decide whether he should carry on being educated as a Protestant or be sent to a Catholic education, the education of his late father. After his discussion with the child, which ranged from matters of transubstantiation to papal authority, Knight Bruce was convinced that the boy was really a determined Protestant and it would be a bad thing for him to go back to a Catholic education. More broadly, that seemed to suggest that the best interests of the child were the matter to be taken into account rather than simply the matter of the father's faith. Later judges were a little bit more sceptical about how rational a religious conversation you could really have with a 9-year-old, particularly one that might have been coached, and so they then tended to follow the father's wishes. But the case law moves in both directions. Before the Guardianship of Infants Act of 1886, the position of married women was much weaker than the position of their husbands. Even where no testamentary guardian had been appointed, the mother's rights might be qualified, and that happened particularly with the case of poorer mothers. And that can be seen from the habeas corpus application of Mary Ann Turner's poor widowed mother in 1872, and this was one of the cases where the child was in a Protestant home and she wanted it moved to a Catholic home. Affidavits were produced to the judge in chambers to show that she'd neglected the child, that she'd been a drunkard, she'd been engaged in immoral practices, and Justice Blackburn, in deciding the case, decided that the court should look whether it would be injurious to the child to return it to the mother. If she was not suitable as a mother, then she shouldn't go back to the mother's custody, and it didn't matter if the mother wasn't going to take the child, but was going to put it in another home. As he put it, quote, "A child is not to be handed over as if it were a load of corn or a bale of goods," unquote. So here, again, they're thinking of the best interests of the child. In the case of mothers, in a way, they weren't necessarily thinking of the best interests of the child so much where the father's rights were at stake. When it came to illegitimate children, the law was more unsettled. A bastard child was, of course, filius nullius, the child of no one, and therefore neither parent had a legal right to custody. Early 19th century courts did allow mothers to use habeas corpus writs to recover the custody of children within the age of nurture, that's to say under the age of 7, particularly from fathers who wanted custody so that they wouldn't have to pay the parish for their upkeep. It's kind of cheaper to take your child back than to have a kind of bastardy bond where you had to pay the parish until the child was of age, and even beyond. But the mother's right to older children was ambiguous. In 1841, a court refused to give the custody of an 11-year-old illegitimate child to her mother when the child herself objected. And Justice Moore, during argument, asked counsel, how does the mother of an illegitimate child differ from a stranger to her? In law, they were strangers. The court also appeared to be more willing to ask the illegitimate child what it wanted than in the religious disputes concerning legitimate children. The court's inclination to look at the best interests of the child in the case of illegitimate children can be seen in a dispute in 1885 involving two of the children of the last Prince of Bengal, Nawab Nazim, the Nawab Nazim of Bengal, Syed Mansur Ali. Sarah Begum, one of his wives, sought to recover custody of her children after his death. Sarah Venel, as she then was a 17-year-old chambermaid working at a hotel which Ali visited in London when he was over pursuing financial gain claims against the government. She married him under Muslim rites. He had other wives in India, but she agreed that her children, she then had 4 children, would be raised as Muslims under the father's control. In 1880, however, the Nawab began to have an affair with her maid, Julia, whom he soon married. She became another wife. And faced with this, Sarah refused to live with him any longer. The children went back with their father to India without her consent. Then, before he died, he appointed guardians for the children and determined that they should be the boys. She had 2 boys and 2 girls. The 2 boys should be sent to school in England. Applying for custody in England after his death, Sarah claimed that the Muslim marriage was not recognised as valid in English law, and therefore the children were illegitimate. The court was very uncomfortable being asked to pronounce on the validity or otherwise of a Muslim marriage, but Justice Chitty pointed out that in any case, under English law, the mother of an illegitimate child was not its guardian. When dealing with such children, the court would look at the child's best interest. And Chitty thought that it would be unwise to disrupt their lives and defeat the arrangements of their father, and therefore she was denied the custody of the children because the court thought, in that case, not that it was simply the father's parental rights because of the ambiguity of the marriage, but because it was the best interests of their children. There were also cases, however, particularly after the fusion of law and equity, where the courts were more willing to recognise the rights of the mother of an illegitimate child. And this can be seen from the case of the Queen against Nash in 1882, where the mother of the child, Rose Carey, the mother, sought to recover her child that she had entrusted to a poor couple, Mr. and Mrs. Nash. Rose was not a woman of high repute. She had been a prostitute. By the time she made the application, she was a kept woman. She was living as a mistress of a gentleman, and so questions were raised about her moral fitness. But it was a balanced case because the couple, Emma and William Nash, who had brought up the child more or less since it was born, were quite poor, and at the time of the hearing, they had temporarily put the child into one of Dr. Barnardo's homes. As for the mother, well, her sister and brother-in-law, who were rather better off and more respectable, were offering to take charge of the child. The Court of Appeal, therefore, rejected the Nash's argument that the mother was a mere stranger to the child, picking up that mid-century dictum. Sir George Jessel, the Master of the Rolls, said that after the fusion of law and equity, the question now also depended on equitable doctrines, where, he said, regard is always had to the mother, the putative father, and the relations on the mother's side. I'm not sure quite where he got that from, because I don't think the earlier Chancery case law suggests it, but he certainly had this idea that this is what equity should be doing, and the rest of the court agreed. So it's partly to do with the welfare of the children, but also recognising maternal rights. So the issue of religious education came to the fore when John Roddy came to the court. One point to mention before we get onto the law is to note that Barnardo was not embarrassed by the litigation, but rather he publicised it very widely. You can see here his magazine, Night and Day, and this is a number with a leading article on Roman Catholics and my children. And my children, you can see that's what he's talking about. And you can see in the 25th report of Dr. Barnardo's homes, you have here, he's talking precisely about this case, the case of John James Roddy. The boy, aged 10, when admitted, was the illegitimate son of a woman who's since married another man with whom she had been living previous to marriage, who was not the father of the boy. She declared when making the application that she was a Protestant. I found that her boy had always been brought up as a Protestant, and as has her only other child, a daughter now married. The boy, John, before admission, lived in a chronic condition of misery and want. He was constantly observed late at night wandering the streets. While it was alleged his mother was in public houses, he was insufficiently clothed. So he's telling the story about the bad mother, her religious manipulation, and the bad condition of the son. Barnardo was aware of the case law that I've just mentioned when it came to the custody of children. In response to Leathley's inquiries about John, Barnardo said, I do not see why a woman of such a type as Mrs. McHugh is should be allowed to take the boy back. Echoing the phrase used in Mary Ann Turner's case, he objected that the boy be handed over like a bale of goods. This is the phrase used in his correspondence. He followed this up by saying that he looked into Mrs. McHugh's character and found evidence of continued neglect, cruelty, and even brutality. He began assembling evidence of her bad character. He sent a missionary, Mrs. Elizabeth Abbott, to follow Margaret around. You can see this is her affidavit in the litigation, paragraph 3. Pursuant to my instructions, I began to make careful inquiries before I first visited Mrs. McHugh, and learned on every side that she bore the reputation of being a drunken, dissipated woman. And to ascertain how far this reputation was supported by facts, I gave myself up for some time to carefully watching her. Mrs. Abbott reported that Margaret regularly went to pubs and that she'd been carrying on in what she called an indecent, disgusting manner with men. She also claimed that that Margaret had told her that she would be happy for the boy to be moved to London, where she could visit him, but that the Catholics had told her not to do that, and had promised her money if they went along with her. And she said, if she didn't get the money, I will make them suffer, for I'm not myself a Catholic and never was. This is Mrs. Abbott's evidence. Barnardo also got affidavits from a number of neighbours who described her as a low, drunken woman. There was also evidence collected about her religion. that her daughter said that she had not really gone to Catholic Church, except on the day that she married. The father said that he was a Protestant and wanted his son brought up in the same faith. There was also evidence that John had been baptized in 1880 at the Catholic Church of Our Lady in St John's Wood, but Barnardo produced a certificate from St Augustine's Anglican Church in Kilburn, which showed that he'd been baptized there. Now, this was not uncommon. Poor people in the East End in this era often had their children baptized in more than one place because, if nothing else, it qualified you for charity if things went downhill. Dudley Leathley also gathered affidavits to challenge this image of his client. For instance, affidavits from the pubs mentioned by Mrs. Abbott said that they'd never seen her drunk or misconduct herself. Others testified that she was a good mother. Barnardo wasn't helped by the fact that recent changes in the rules of the Supreme Court in 1886 said that parties who gave affidavits in these cases could be cross-examined, and this was done. One of them, Mrs. Elizabeth Still, whose affidavit said that when the boy had left for Dr. Barnardo's homes, he was dressed in very poor clothing, mainly rags. This turned out to contradict a statement by Mrs. McHugh's employer, who said that she'd given the boy clothes from her own son for when he went into Dr. Barnardo's home. And on cross-examination, Mrs. Still said she couldn't remember using the word rags, but she did remember that the employer had given the boy clothes and that he had worn them when he had gone into the home. The court was also concerned about how Dr. Barnardo had assembled his affidavits. Her husband, William Still, also gave evidence about Margaret's character, and his affidavit had bits struck out. So you can see here, the said Margaret McHugh is a person who bears a bad character in the neighbourhood and is, in my opinion, totally unfit to have the custody or control of any child. And you can see the bit about the character is struck out. The bit that is remaining looks fairly formulaic. That was found in many of the other affidavits. His opponents began to suggest that the affidavits had been brought to witnesses ready prepared or ready to be filled up. William himself said that he couldn't read. He was illiterate, and they had come with a prepared affidavit, and he had said what he agreed with and what he didn't agree with. So Barnardo's opponent said, well, this was a man who manufactured these before and after pictures. Is he manufacturing these affidavits? And so instead of being seen as the great saviour of orphan children, they were portraying him as a man who would do anything to deny a poor woman access to her child. Dr. Barnardo's case was premised on the approach taken in Mary Ann Turner's case and Sarah Begum's case, that the mother of an illegitimate child had no legal rights, and that the court would take into account her character and the bona fides of her request to change its religious education, but that the court should look to its best interests. On the other side, it was argued that mothers of illegitimate children had exactly the same rights to determine its religious education as the father in the famous Agar Ellis case. There's an indication that the courts might lean to the best interest view because they interviewed John privately in their rooms. They found him to be intelligent, well-nurtured, healthy. He was evidently happy at Barnardo's and said that he wanted to stay there, even though he also wanted to be able to see his mother. But the court clearly disapproved of Barnardo's methods. In the words of Lord Coleridge, it's intolerable that inquisitorial proceedings of this kind should be set on foot in regard to the mother of a child by a person who has no legal right whatever to his custody. Rather than focusing on the desires of the child, Coleridge looked to the mother's rights, which had previously been downplayed in many cases. In his view, the fact that the child was illegitimate made no difference to the mother's rights. She could only lose the custody of the child if she had been guilty of such gross immorality as would endanger it, which was the test traditionally used for the fathers of legitimate children. Within a week of the judgment being handed down, Dr. Barnardo took his case to the Court of Appeal, where he argued the case himself. He argued that the mother of an illegitimate child did not have the rights of the father of a legitimate one, that she could waive her rights by agreements, that the court should only look at the child's best interests, and that religion was relevant, and that the boy might have had enough Protestantism instilled in him that he shouldn't be made to go to a different school. But he lost again. Lord Lindley, in this court, noted that the law relating to illegitimate children was still relatively unsettled, but that recent case law had suggested that the mother of such a child had a prima facie case. And he also felt that the boy was not old enough yet to make up its mind on religion. Having lost again, Barnardo went to the House of Lords, where he failed again. Like Jessel in the Nash case, judges distinguished between the strict legal rights of guardianship of common law and equity's recognition of the mother's natural or moral rights. They interpreted Jessel's view as indicating that in equity, the desire of the mother of an illegitimate child to the custody of the case is primarily to be considered. So it was really putting the focus on that. The wishes of the father in this case were therefore to be ignored, and the child, again, they agreed that he was too young to decide for himself. So it was a curious mixture of doctrines with certain trends from common law ideas about paternal rights being mixed up with an equitable idea that they should apply to women, but in a way that diverted you from necessarily looking at the best interests of the child, which in other cases had been seen to be the equitable approach. Barnardo had to surrender the child, but the canny publicist managed to restore his character in the higher courts and lost no opportunity of reminding his readers that criticisms made of his conduct in the lower court had not been repeated in the higher courts. And indeed, he was able to make use of the litigation to help generate more funds. I won't read this letter, but this is a postscript, then it's inserted in Night and Day, where he defends his conduct and says he must do it, and says, also, this might be I will be very grateful for you both to support the homes and to support my litigation. And we'll see in a while a little bit more that his friends got legislation passed, the Custody of Children Act of 1891, which, while it provided guarantees for the religious choices of the parents, made it very much more difficult for parents to remove children that they'd committed into homes for orphans, and he was able, therefore, to use that to defend his right to keep children against Catholic mothers. But by the time that act passed, he's already embroiled in the second case we're going to look at, that of Henry Gossage. So in the case of John Jones, it's simply a question of trying to keep the child on the grounds that the mother was unfit and that the boy needed to be kept in the same religion that he'd got used to and that he was perfectly happy in the homes. In other cases, he resorted to more draconian tactics. And one of them was to place children entrusted to his care, send them to inaccessible places. In two cases in which he anticipated writs of habeas corpus from Catholic lawyers, Barnardo gave children to effectively complete strangers to take them out of the country. And the case of two children, Martha Ann Tighe and Henry Gossage, proved particularly controversial because they were both sent to Canada, where he had his homes, but with no way of tracing them. These cases would raise a novel legal point. As we've seen, the legal instrument used to recover children by parents was the writ of habeas corpus, which had been used for these purposes since the 17th century. But the writ was used against the person who had the custody of the child you wanted to recover. And if you didn't have the custody, the writ shouldn't work. There's a case not involving a child, but a person suffering from mental illness, the King Against Right in 1733, where a writ is issued to the medical practitioner in whose care the person was put. Dr. Ryder initially fails to respond, but then says, I actually restored the patient to her husband, and I've had nothing to do with the person ever since. And the court said, that's fine, that's a perfectly good return. Dr. Wright had clearly acted bona fide, but when it came to sectarian disputes, it was clear that people with high religious principles might act in ways that defied the writ. There are very few cases of that sort in England, but there were a raft of them in Ireland in the mid-century, particularly in the years when Barnardo was growing up in Dublin. There's a great deal of sectarian dispute between Catholics and Protestants and about moving them from one home to another. The most prominent cases involved Catholic agencies trying to remove children that after the famine were being put into Protestant homes by Protestant agencies. In these cases, the Irish courts took a very tough approach, using the writ to attempt to force the activists who had taken children to produce them at times when they were apparently no longer under their control. One of the leading campaigners, and I have no image of Margaret Elwood, but there was a relatively recent biography of her as well. She was one of the main campaigners who gets into hot water about the way she's acting. She founded St Bridget's Orphanage in Dublin in 1856, which took in many orphans. One of the orphans that she took was a child called Mary Matthews. The child's father, who by then was dead, had wanted her to be educated a Catholic, but her mother, who'd been abroad and only returned to Ireland in 1858, wanted to take her out of the Catholic home and give her a Protestant education, very much the sort of thing that we find with Barnardo later on. When a habeas writ was issued, Miss Aylward said that she'd put the child out to a nurse a few miles out of Dublin and would not reveal where she was. She didn't want to say who the nurse was. In the meantime, there was a ruse where they disposed of the child. The child was taken away from the nurse with the story that a stranger had come with a letter from Miss Aylward authorising him to take the child away. They didn't know who it was, and he had disappeared. The Irish King's Bench took a very tough view of her conduct. As Justice Hayes put it, when a child was traced to the custody of a person without the right to the child, that person in the eye of the law becomes responsible for its safety. The process went on, and the court became convinced that there had actually been a strategy between Miss Aylward and the nurse to make sure the child was moved away untraceably before the Protestants got to her. And the result was that Miss Aylward was sentenced to 6 months in prison for her contempt of court, which she then served. So that's the kind of background to the case of Gossage. I don't have a picture even from Night and Day, but this is a kind of similar image of the kind of image that Barnardo would have wanted to portray of Henry Gossage. Originally from Leamington, Henry had, according to Barnardo, been sold by his drunken and dissolute mother to 2 organ grinders. After tramping around the country with the organ grinders for 4 months, they abandoned him in Folkestone in September 1888, where he was picked up on the streets by an Anglican priest who handed him over to Dr Barnardo, the best known saviour of poor children. After the boy had entered Barnardo's home, he traced the mother, and the mother said she would be pleased to have him keep her son, as she confirmed that her 2 older sons had actually been sent to Canada. In fact, they'd been sent by a Catholic agency to Canada. Unlike Margaret McHugh, she didn't sign the agreement. 2 months afterwards, Barnardo received a letter on her behalf to say that she wanted the child to be put into a Catholic home, St Vincent's Home on Harrow Road. On the same day that the letter was written, Barnardo first met a man by the name of William Norton, a Canadian who wanted to adopt a boy. Although Barnardo usually took a lot of care in selecting the children who were to go to his own homes in Canada, Barnardo took no precautions in this case. 5 days after meeting him, he entrusted Henry to this Canadian, about whom he knew more or less nothing except the fact that he was a Presbyterian. Norton also, according to Barnardo, refused to disclose his address because he said it was common for birth parents in Canada to try and find their children again, and he didn't want this to happen, so he didn't want to be traceable. And Barnardo apparently said, that's fine, I understand that. In the meantime, having done this, and of course this is done precisely when he knows that there are efforts afoot to recover the child, he stalls when inquiries are made about the boy by St. Vincent's. He writes back, holding letters that don't give any information. Eventually, in January 1889, when he received a letter threatening him with a habeas corpus proceeding, he sent a response saying that Henry Gossage is not and has not been for a considerable time under the control of the managers of these institutions. We don't have him. Mrs. Ford's habeas application, brought by Mr. Leatley on behalf of the Catholics, failed when Justice Matthews accepted Barnardo's affidavit that the child was no longer under his control. So that seemed to be the end of the matter, but it wasn't, because there was a second case, that of Martha Tighe, which reopened these questions. Martha is a more or less similar story. Her mother, Margaret Ward, had entrusted the child, Martha, to Dr. Barnardo in July of 1888 for a 2-year term. It was a limited term in her case. But at the end of a year, she wanted her daughter's return, again, to go to a Catholic education. Anticipating the expected letter from Dudley Leatley, Barnardo moved to dispose of the child. In this case, a French-Canadian woman by the name of Madame Roman was given the child, although he keeps some kind of contact with her. Unlike Norton, he doesn't have no means of communication. In January 1889, Barnardo was served with a writ, and in response, he said Mrs. Ward had agreed, she had signed the agreement, and she had agreed to the child going anywhere in the empire, and that he had done that. He said that he had given the child to Mrs. Roman, who refused to say where the child was and refused to return him. Nothing more I can do. So he said he had no control over the child. This did not satisfy Justice Matthew on this occasion. He said the return was evasive and unsatisfactory, and he issued an attachment. Barnardo then went to the Court of Appeal, which confirmed that the facts stated in the return were not an excuse and that the attachment had to issue. The court rejected the argument that the fact that he'd parted with the child before the writ had issued should exonerate him. And the Court of Appeal seemed to echo the view of the Irish King's Bench. As Lord Justice Lindley put it, persons who illegally put a child out of their power do so at their peril, and if they are ordered to produce the child, no excuse founded on their own inability to comply with the order will be held sufficient to answer the writ. So you really have to produce the child. Barnardo failed to produce the child after the Court of Appeal's order, and proceedings were commenced against him for contempt of court. He was examined on interrogatories by the Master of the Crown Office, in which he testified that he had been to Brussels and Cannes, where Madame Roman said she had gone first. He'd given instructions to find the child, and he had failed to locate her. So he's saying, I've done as much as I can. And at this point, the case was going to go forward, but the court decided it wasn't going to decide what happened next, because it was at this point that the proceedings in Harry Gossage's case had reached the stage where they were going to go to the House of Lords. The decision in Gossage's case was going to determine what would happen in both. So, what had happened after the first successful attempt by Martha Tighe's mother to recover custody of the child was lots of applications came in. That's when a renewed application was made for Harry Gossage. In resisting the writ, Barnardo again made the same arguments that he had made in other cases. He'd argued, as you can see here, he actually tells all of his readers everything that he's arguing. He keeps them abreast of it. The immoral and cruel conduct of the mother said she was indifferent to the boy's fate and was not in any way solicitous concerning his religious future. The application wasn't made by the mother, but by other people who were not interested. He'd already placed the boy in a good home in Canada. The father was a Protestant. These are the kind of normal arguments that he's putting forward and telling his readers about. But those arguments cut no ice. The court was no longer interested in that. It was interested in the question that he wasn't producing the boy. Lord Coleridge, who heard the case, dismissed Barnardo's arguments that he couldn't produce the child. He said, "You must produce him. You had no business to get rid of the child, and therefore the law deems the child to be virtually in your custody." Following January, Barnardo goes to the Court of Appeal to challenge this. The Court of Appeal upholds the lower court decision, but it's now beginning to explain what the law of habeas corpus means. Is it the case, as the Thai decision seemed to suggest, that if you have had a child, you've disposed of it, you no longer have any means of recovering it, you're liable to an attachment, you're liable to punishment? Lord Isha in the Court of Appeal said the writ would not issue if it was absolutely impossible for you to produce the child, but he said it's no excuse for the defendant to show that he had illegally parted with the possession of the child under such circumstances that it would be extremely difficult or almost impossible for him to produce the child. So you really have to be quite sure that it's impossible before the writ will not issue. Having lost again, Barnardo returned to the Lords, and again you can see here he prints his speech in full in Night and Day before my judges. The Lords, though, again come up with the view that he has to do more. The Lords do reject the baseline view in Thai's case that the writ could be used in effect to punish a person who can't produce the body. If it's impossible for you to produce the body, the writ does not run. But as Lord Halsbury put it, there's an important rider. Of course, he said, where a counterfeited release has taken place and a pretended ignorance of the place of custody or of the identity of the custodian is insisted on, a court may and ought to examine into the facts by a writ of habeas corpus, because the detention is in fact being continued by someone who is really the agent of the original wrongdoer to continue and persist in the unlawful detention. So this meant that the court had to be convinced that there was at least some measure of control, but it can't be simply a method of punishment. That, though, was not the end of the matter for Dr. Barnardo, because the dispute so far had been over whether the writ should issue, and they decide that the writ should issue, and that they will see what he says in the return, and they would decide on that subsequently. Barnardo made his return in November and stated that since the 16th of November 1888, he had not had Harry in his custody, power or control, and he'd had no communication with William Norton ever since. He said, "I have by my agent in Canada and by employing skilled detectives sought and endeavoured, and am still seeking and endeavouring to the best of my ability to discover the said Harry Gossage, but I have been unable to discover him or obtain intelligence or information about him. I am therefore unable to obey the writ." Mrs. Ford's lawyers were not happy with this. They traversed the return, and the court therefore agreed to investigate the truth of the return and gave time for filing further affidavits. He was not going to be left off the hook so easily. Barnardo responded by giving his own commentary on the Lord's decision in Night and Day. You see at the top the true story of Harry Gossage. In it, he disparaged the mother again, said the judges had been hoodwinked by her counsel. For his pains in writing about it while the case was still going on, he was fined £25 for contempt of court, and costs were imposed. The matter wasn't determined until May 1893, when the case came before Baron Pollock and Justice Hawkins. This time he had to supplement his affidavit by speaking in court. In the end, the judges accepted that he couldn't return the child, that he really had done all he could, but they were far from happy. According to a press report, Justice Hawkins said that the circumstances under which the boy was parted with created suspicion, and the shifty nature of the correspondence increased that suspicion. He said the affidavits made him suspect there was no such person as Mr. William Norton of Quebec, and he was very suspicious about the truth of the return. But being merely suspicious about the truth of the return wasn't enough. There was nothing further they could do. In the end, neither Martha Tye nor Henry Gossage were returned to Catholic educations in London. So to that degree, the two cases which reached the Lords resulted in a victory for Barnardo, whose main goal, after all, had been to prevent these children going to a Catholic home. There was some reputational harm done to Barnardo, since his methods were seen to be at least questionable, but he still had his supporters, including a number of senior judges. For instance, in Margaret McHugh's case, Lord Esher made it clear that he didn't agree with Lord Coleridge's criticisms of Barnardo's character. He said he had never come across a Catholic institution rescuing a child and then having Protestants trying to take the child out of the Catholic home. And he said, to my mind, Dr. Barnardo is the better scavenger of the two and picks up most of the gutter children. Nothing like kind of engaging in the sectarian dispute in passing. And of course, Barnardo's legal position, as I've already mentioned, was helped by the Custody of Children Act, which he used to resist giving back 80 further children. So he does get some results. So the cases we've looked at are interesting, I think, both from the kind of point of view of the story of Dr. Barnardo's methods and the disputes about children, but also I think they have some legal significance. Margaret McHugh's case, the House of Lords gave important recognition to the mothers of illegitimate children, putting them effectively on a par with the fathers of legitimate children, recognising their rights. In Barnardo and Ford, the court made repeated attempts to test Barnardo's assertions that he had no de facto control to see whether they were true, and it went a very long way to ensuring that the writ would be obeyed, but without changing its nature. Thank you very much.
Well, what a powerful work of scholarship. Thank you very much indeed. I was sitting there thinking, as family lawyers quite often here, people say, well, the thing about family law is there's not really any law in it. Well, we have just a little time for any questions, if there are any. No? Yes? Please.
Thank you very much. I was wondering if you could elaborate on any justification that Barnardo gave for the monetary conditions of return of children to their parents. Was there at any point where he justified this particular clause?
I think I think he simply saw it as a kind of a neutral kind of thing, that if you're giving your child to us to look after, and we are spending a great deal of money, then it's only fair that you need to pay for the money that we have had to pay. I think he would have, he justified it as that straightforward, you would be unjustly enriched if you let us bring up your child without paying for it. But effectively, it was a straightforward disincentive. It was simply put there so that mothers would feel that they couldn't take the child back. And certainly in Mrs. McHugh's case, one of the first things he does is he writes to Leithley saying straightforwardly, we know that she's a bad character and this will all come out. He writes to Mrs. McHugh and says, we know about your moral character. Do you really want this all to come out before the world? And by the way, you will owe us all of this kind of money. So the justification in terms of conflict is not a kind of, let's be reasonable and rational about this. It's, it's threatening and designed to be.
I've got, yes, so do please, yes.
Thank you. From your talk, I've got the impression that Dr. Barnardo was a bigot and a control freak. Is that fair?
Well, that's certainly how he is portrayed by his enemies. The curious thing about it is, during the kind of press campaigns, particularly in 1890s, there's a lot of very severe criticism. People look at this and say, this is a very bad way to behave. But he has his defenders. And the fact that he has his publicity machine, he's not hiding what he's doing. I mean, the threatening letters don't get published in Night and Day, but the rest of it gets put forward. I think he's putting himself forward as the defender of children against bigots. So again, it's this sectarian battle where both sides are seeing each other as bigots, and they're both kind of trying to dig their own heels in. So certainly his methods are dubious. He justifies it by saying, A, they're very much better off under my care than with their parents, and B, they're better off under my care than the Catholics. And the public probably say the first one is true, and probably in largely Protestant England in the 1890s, many of them are inclined, like Lord Esher, to agree on the other one as well.
I'm not sure you've answered my question.
Right. Well, maybe I should say, you may say so, but I couldn't possibly comment.
Thank you very much. Absolutely fascinating. There's so much there to unpick. My sort of immediate thoughts went back to the case of Agar Ellis, and I think it was the Master of the Rolls, Brett, who said a father's rights are his sacred rights because his duties are sacred duties. And you talked a bit about the mixture of doctrine, and then of course the willingness to overturn, if you like, the moral right of a mother to the illegitimate child. But I just want to pick up on this bigoted and was it coercive point. But I was just thinking in today's kind of notion, is he trafficking? Could he be seen as trafficking children to Canada? Why did he send them to Canada? Or is it at the crossroads of what we saw in the 70s with adoption, where the consent issue was always debated in a series of cases about a parent who refused consent, and then the courts were stuck with grappling with whether the consent was reasonable or unreasonable. And I never could fully understand any of that, but there were long judgments about whether it was reasonable or unreasonable. And of course, it did cut across the other moral issues, which are clear with Barnardo, that in a sense, was he also the early care proceedings man? I mean, he may have been a bigot, he may have been coercive. Women may have been coerced into giving up their children, but, there are so many themes that sort of get us to think forward and backwards with how the laws developed. So I've got a number of questions, I think, embedded in that, and I'm sure you can respond to some of those.
Well, on the trafficking issue, I suppose the baseline justification that Barnardo had was his homes were providing good environments and safe environments for children who would otherwise not be in safe environments. And the majority of the children who went to Canada were not like Martha Tye or Harry Gossage. They were children who, as I said, were carefully selected, and the parents had agreed to the children being sent and so on. But these are exceptional cases where clearly this is clear. He's sending them away without any going out of his way to spin along the legal process to give himself time to spirit them away before questions can be asked by anyone, and that clearly is a kind of trafficking, is illegitimate. But yes, more in the more kind of wholesale picture, there's a reason why the homes have a very good reputation, and why he's why sending children to Canada, which of course is part of the empire, wholesome, a place to send children to, and so on. On the question about the Agar Ellis case, yes, it's an interesting case. It's got its own peculiarities in the sense that the children are living with their father, and it's a dispute between the mother and the father over him going back on his agreement when they got married that they should be brought up as Catholics, and not whether they should remain in his custody, but whether they should be allowed to go to a Catholic service, and whether he has complete control over them. After the first case, which decides absolutely that he has the full right, he does agree to let them go to Catholic masses, and then the second case is about whether the 16-year-old can decide for herself and visit her mother and so on. And then again, it's the father has complete control until the age of majority. Later on, Brett, when he becomes Esher, seems to change his mind in subsequent cases. But there are often cases where the child is not living with a father, but for example, it's a dispute with a mother. There's a case involving Queen against Jingle in the 1890s, where he seems to change his view. So Ben Griffin in his work talks about this, whether Brett represents a kind of conservative common law position in Agar Ellis that then softens when he gets more exposed to the equity lawyers, and then he kind of begins to look more at the welfare of the child in a way he hadn't been interested before. I think it's a hard argument to make because the peculiarities of each case are such that they can be distinguished just on the position of the families.
Well, thank you. I think we're really up to the time where we should be heading off towards the drinks. I therefore should really apologise to the people who are with us online. There are twice as many people online as there are in the lecture theatre, which is very much the position we had during the post-COVID period. And that had begun to swing back, but I don't know why now, at the moment, we had that proportion this evening. But I must apologise to them for not giving them an opportunity to ask questions, but there really wasn't time, and we took the present ones that were in the lecture theatre at the time. So thank you very much for watching online. I hope it was all clear. If anybody wants to listen again to this, it will be on the Inner Temple website, and perhaps not the full talk, but certainly a summary of it will be produced in the Inner Temple yearbook for those who want to remind themselves of it. Now I just falls to me to say, well, Michael, thank you for a fascinating talk. I'm most grateful to you.
Thank you. Thank you.